Yes, your lordship.
Yes.
Lordships, I would like to make a mention item 8 and 16. That is first and last hearing items, Alpha and Omega. These two matters may be tested up to 4 weeks, lordship.
Okay. 8 and
16. 8 plus 8, 16.
Learner Senior Advocate Mr. C.T. Jamir has submitted for adjournment. List the matter after 4 weeks.
Lordship. Right.
Can I please, Your Lordship? I beg to mention hearing item number 13.
Yes.
We have the consent from the other parties. So kindly let the matter be listed on 20th of August.
POSCO?
20,
Okay, 20 August. POSCO matter. Learned Counsel Miss
Kokla.
so and so. On behalf of anybody?
Cynthia Mer.
On behalf of Learned Counsel, Mr. Sentianga has submitted for adjournment. List the matter after 4 weeks. On
Matter
20th
20th
August.
August.
On 20th, 20 August. Okay, on 20th August.
I would also like to mention hearing item number 11 on behalf of the public prosecutor NIA.
On behalf of PPNI.
Yes. Kindly let the matter be listed after 3 weeks.
Okay, Learned Counsel Miss so and so on behalf of PP and I, Mr. Anand Mishra. No.
Mm.
Respondent. NI is the complainant.
The NIA BP.
Appellant. On behalf of okay, PP NIA has submitted for adjournment. Do you have any objection from this side? With the consent, you just include with the consent of the other side, somewhere you include it. List the matter after
3 weeks.
3 weeks. All right. Mhm.
And this ladyship's
Mm.
item number 12.
Yes.
Here, the state is appellant.
Mm.
My ladyship, my lady, Bang Kumar is against her judgment.
Oh.
So,
Okay, okay. Place before any bench without.
yes.
Okay. Ready to place this matter before any other bench without any other bench without judge. You give judge's name. List the matter after 1 to
1 week.
1 week. This was item number 12.
Yes.
Okay.
The lordship, I'd like to mention item number 14. Lordship, in this matter.
Oh, you have circulated leave yesterday, no? For item number
Yes.
14, somebody has circulated leave yesterday.
Adjournment request is already there.
A leave request has been circulated. List the matter after 2 weeks, 3
2
weeks, 2 weeks. Okay.
Lordship, I'd also like to mention item 15, Lordship.
Mm.
Lordship, if this matter can come up after 2 weeks,
Okay.
I'm taking the consent.
Learned PP, no?
Lordship,
PP, Mr.
Digimon.
B. Vijimomi has prayed for adjournment. List the matter after 2 weeks.
This is Roshan.
Mm.
I would like to mention item number 10.
10.
The function of the other parties. This matter will come up to 3 weeks.
Learned Counsel, Mr.
Mr. Tanada, Madam, Your Lordship, I'm appearing on behalf of Mr. Joshua Shekhe.
Okay. Your name?
Tanada,
Mr. So and so on behalf of Learned Counsel, Mr. Joshua Sheke has prayed for adjournment. List the matter after
3 weeks.
3 weeks. Okay. Mm.
This Lordship,
Mm.
I'd like to mention item number 1 and 2.
1 and 2.
Regarding disposal.
Bail. Bail.
Yes, Lordship.
1 and 2. Okay.
This matter will come out after 3 weeks.
After
3 weeks.
3 weeks. Learned Counsel, Mr.
On
Uh,
behalf of the issue.
so and so on behalf of learned counsel, Mr. V. Theo has prayed for adjournment. List the matter after how many weeks? 3 weeks. Okay.
Please, Lordship.
Mm,
My lord, hearing item 9,
mm,
I have been appointed. Am I just?
mm,
I'm prepared to argue today, but there's a small mistake in the petition. I could not cross check my
mm,
junior file.
mm.
So I may be allowed to withdraw that today and file tomorrow. That
What,
I'll rectify.
what?
Affidavit, there's a slight.
Only affidavit. Only nothing else more than
Nothing
affidavit?
else.
All right.
Nothing else, just affidavit. It's a jelly,
Okay.
but I did
You
not
want
cross check.
to submit you want to withdraw this affidavit and file a new affidavit?
The entire appeal and meet, I'll file tomorrow.
No, appeal you cannot withdraw.
Okay, then.
Appeal, you will have to
You may be allowed to rectify.
decide on merits, huh?
Actually, this is jail appeal.
Even
So-
then, appeal cannot be.
No, but I'm trying, this jail appeal, so.
You just want to rectify
Yeah,
something.
rectify, because I'll be very honest, I did not. cross
When
check.
through a application, you want to rectify it through an application.
I can do that,
Okay.
because unless I do that, it is wrong on my part.
Okay.
Because when this is jail appeal, the accused in jail cannot come and sign.
Mm.
Otherwise, I'm prepared to argue, I thought I'll just finish it this one today.
Doesn't matter, it's okay. So which item?
Item 9,
9.
yes.
Learned counsel, Mr.
Age of-
A. Jho has submitted for time to file an affidavit for rectification.
Yeah, of the affidavit.
File an application for rectification.
Yeah, okay.
Affidavit,
Part.
File an application stroke affidavit for rectification, whatever you want to submit. Okay, in whatever manner you want to rectify. Learned government advocate, PP. Learned additional PP. PP, Mr.
Okay.
K. Angami is present. List the matter after.
And next, I'll just,
Next week.
next week, within 2 days, I'll just.
After 1 week.
Next week.
Okay.
March of that.
Mm.
For admission, item number 3.
May I please, your ladyship's
Mm.
I file on behalf of the alleged accused person who is presently custody in Mabur District Jail
Mm.
under PIT in DPS Act. The
Okay,
lady-
P10
Madam. The lady, she's Sarah, she was arrested on 10 of August 2024.
10 August 1224. 10 August 24.
Yes,
Okay.
that was almost a year now.
Mm.
She's still in custody without any bail. And while she was on the verge of about to get a default bail, the detaining authority, they have slapped the PIT in DPS on her when she was about the verge of about to get the
Mm.
default bail.
Yes.
However, the land report below has granted default bail to her after attaining the 6 months period of the
Mm.
180 days.
Mm.
My lord,
Mm.
I like to state that because of my further my arrest somewhere in 2018 and similar in this case, my lord, the
Mm.
trial is yet to be completed. I have been witch hunting and for many allegations and cases the police personnel are slapping on me. In this case, and Annex 1, Your Honor, I put one FIR. FIR.
Mm.
Annex
Yes.
1, may I read out for you? Annex 2,
Page.
27, Your Honor. It is-
Annexure 2, page 27.
Yes, Your Honor. It is.
Yes.
Subject, report regarding disclosure by an accused. May I read out, Your Honor, please?
Page 27, just a moment. Yes, yes.
Sir, with reference to narcotic PS case number so and so, I have the honor to state that during the custodial interrogation of arrested accused, Chakis, son of David, resident of so and so, it has come to fall that he has taken narcotic drugs on numerous instances from one Mr. Tahar so and so with mobile number so and so and further supplied to parties based in Manipur, Nagaland, Assam, and other parts of India. Based on the disclosure of the accused persons in the CDR analysis, Darher is found suspect to be the main supplier and to have involved in a large network of drugs trafficking and smuggling narcotic drug interstate. Darher is in communication with mobile number so and so to purchase and supply of narcotic drugs in large quantities employing timber and LB trucks. Darher is also in communication with Sarah. This is me, Darher is also in communication with Sarah and Puffy Show. Darher is also attempted to deliver narcotic drugs to Dimapur so and so. But this, my name has been reflected according to the disclosure of a person who was arrested. And thereafter, I'm a married woman. I have 4 children, but because of my health, I went to Gauhati that last year in August, along with my husband. And
Where you were in?
Gauhati, we went to Gauhati
What?
because of my bad
Can
health.
get you?
Yeah, health. I'm a woman and I have 4 children, and my previous husband died, and now I'm married to Mr. Lakantas. So I went along with my husband to Gauhati for my
Guwahati.
yes.
Okay.
Then in connection to this report, I was arrested. Though nothing was found in my possession, no drugs was recovered from my possession, or no incriminating substance was recovered from me and my husband, but both of us were arrested. Then, while in giving custody, both of us were served with board under this bit in the PSA.
On 4th August, you were arrested
On 10th of August.
and served with this notice.
Yes. And subsequently, this bit in the PS was served upon me and my husband. Then and the person here, the Chakis, who is mentioned in this FIR, they have already been released.
So this person is already released.
Yes.
Jackie's.
Chakis is already released. The other persons in this case, around Your Honor, in this case, I don't know exactly because the other I'm not handling the matter for the other accused persons, but around 9-10 persons were already released in this same case. In this same case number, some other persons were also arrested, but I'm the only person languishing here in
Narcotic
this
PS
case.
case 9 of 2024.
Yes, Your Honor.
Okay.
Thereafter, the advisory report, I've written representation to the advisory report. Then advisory report revoked the detention order of my husband, Lakantas. Now, since they have already got bail, so Lakantas was released thereafter. But
Okay.
mine was not considered. However, there is no reason given by the advisory board on which ground the representation of Mr. Lakantas was considered, or my Saradas was not considered. It is not given. So, considering all these grievances, Your Honor, I came before this honorable court. There are many grounds on which I can submit before this honorable court, but one fundamental which the detention authority ought have to do while issuing a detention authority against me. I want to read out to you before this your lordships, your leaderships. I
Book,
would like
PIT
to,
NDPS book. NDPS Act. You can give the book NDPS Act, two books for each one of us. Yeah, please.
page number 15, para 27.
Yeah.
That's the DTU. But the DTU means the lady Sarah. She is a person of Khmer community of the state of Manipur. This lady is of the Khmer community of the state of Manipur. She speaks Khmer language. She speaks Meitei language, but she's not a literate person. So I'll read further, Mother. Your Lord. She is not an educated person who could grasp and understand the contents of the write-off of the detention order and grounds of detention. She speaks her native language of Khmer and Meitei. That is Manipuri language, Your Honor. However, the detainee was not served or given the documents in the language that she could understand or comprehend. Now, the grounds of arrest or for detention was explained to her in the language and manner that she could understand.
Mm.
Therefore, the acts of commission on the bar of detaining authority is total disregard to the provisions laid down by the law. The Article 22(5) of the Constitution.
Mm.
Article 22,
Mm.
Clause 5.
Constitution also.
The Constitution, Your Honor.
NTPS. NTPS.
Okay. She's from Manipur.
Yes, Your Honor.
Sarah, no?
Sarah, yes. Sarah.
Okay.
She speaks Puma language and Metilon
Oh,
language.
my what language?
Puma language. Puma is a tribe of Senapati.
Oh, my. Okay.
Yeah, Puma language and Metilon.
And
Meti.
Métis.
Yeah, yes, Your Honor. I'll read the constitution currently given to the person
Yes.
under Article 22, Clause 5, Your Honor.
Yes, yes, please.
When any person is detained and pursuance of an order making under any law providing for preventive detention, the authority making the order shall as soon as may be communicate to such persons the grounds on which the order has been made and shall afford him the earliest opportunity to make a representation against the order. Here, Your Honor, our constitution, the highest law of India, states that the grounds of arrest must be communicated to that person. Then, in connection to this, to make it more even more effective and great, I would like to bring to the place you before the decision of the honorable courts, Supreme Courts. This is a matter which was decided on 1962, Your
Mm.
Honor.
It
Ah,
still holds the field?
yes, I will bring it to that.
Mm.
Hari Kisan versus the state of Maharashtra.
Mm.
Your Honor, this is also regarding a detention order.
Mm.
So I would like to bring it to your paragraph 12.
Mm.
Which
Para
is,
12 years.
paragraph 12, which is on page 5.
Mm. Yes.
I will read out for you, Your Ladyship.
Mm.
We do not agree with the High Court and its conclusion that in every case, communication of the grounds of detention in English, so long as it continues to be the official language of the state, is enough compliance with the grounds of the Constitution, well, with the requirements of the Constitution. If the detained person is conversant with the English language, he will naturally be in a position to understand the gravement of the charge against him and the facts and circumstances on which the order of detention is based. But to a person who is not conversant with the English language, in order to satisfy the requirements of the Constitution, the detainee must be given the grounds, Your Honor, yeah, the detainee must be given the grounds in a language which he can understand. Further, is written in a script, which he can read. If he is a literate person,
Okay.
Your Honor, in the script also should be given. Then I think that script was also not given to me. The language that I
You
know.
have annexed a copy of the grounds of arrest?
Grounds of arrest, it is there, but not in the language or script.
No, no,
that-
it's okay. You have annexed the copy
Yes,
given,
ma'am.
given to the
Yeah.
detainee?
Yeah, it is in my.
Yes.
I've also received the affidavit in opposition. I've also checked that it is not there in my Puma language or in Mindilon language. Even in Nagamis also. The police,
Page? Which
Oh.
page of the WPC, grounds of arrest? In which page of your petition?
32,
Okay.
32, 33. Yes, 32 is 33.
In English?
Yes, Your Honor.
Okay.
Besides that, I will, judgment that I've read just now, Your Honor, is 1962 Supreme Court.
But she has received in English, no? Sarah Das.
Yes, please.
Her signature is in English.
Yes, yes.
Okay,
But it's not the script that she knows.
okay.
So this is 1962, the previous judgment. Then the recent judgment, which is still not yet challenged.
Yes, yeah.
I will read it out for you, Your Honor. Your Honor, this is 2025 March. Coincidentally, this also happens to be a case of Nagaland,
Mm,
which was decided by our apex Supreme Court.
okay.
So, my lord, your leadership, I would like to take you to para 12. I would like to start from para 12, Your Honor. The relevant portions.
Mm.
On the same ground,
Yes.
may I read out?
Mm.
Given the settled legal position, as set out Sabra, we are of the opinion that the orders of detention passed against Ashraf Hossain Chaudhary and Atalay Chawang cannot be sustained. The authorities concerned paid mere lip service to the mandatory requirements and mechanically went through the motions while dealing with the cases of these two individuals. The proposal submitted by the investigating officer noted that both the detainees were arrested on 12/4/2024 and they not been released on bail. My lord, I'll take you to para 14 further.
Mm.
Because me also, I'm still in not conduct para 14.
Mm.
Further, it is an admitted fact that neither Ashraf Hossain Chaudhary nor Atailo Chawang knew English. The language in the orders of detention and the supporting documents, they specifically raised this issue in their individual representation dated 12/6/2024. The proposals for the detention also recorded that only languages known to Atailo Chawang were Nagamis, Manipuri, and Hindi, while Ashraf Hossain Chaudhary knew Nagamis, Bengali, and Hindi. However, the authorities claimed that the contents of the orders and grounds of detention were explained to them in Nagamis. Here also similar, madam. They have also written that it's explained in Nagamis, which I've received in my affidavit in opposition. I received that in my opposition that they were explained in Nagamis. And the same would suffice. Continuation further, your leadership. This argument must necessarily fail. This argument must necessarily fail in the light of the law enunciated by the constitutional bench of Harikisan Supra. Such oral communication, even if true, did not amount to adequate communication in terms of Article 2. Yes.
The earlier judgment.
Yes,
1965.
1961 was again referred. This year only again by the apex court in our same Nagaland case. So mine also is once it's shown as English, the script is shown as English, and somewhere it's written as Nagamis, but the script is not given to me either in Meitei loan or in Meitei or in Bumai or even in Nagamis also. I'm not.
But you see, she has signed in English. That is my question to you.
Of course, the name has to be written, signed in alphabets, of course, to be honest, leadership. Any day.
Okay.
The sign the even Meitei loan or Bumai language must be in alphabets. Even my language is also in alphabet.
Okay, okay. In English alphabets.
Yes, even my own language is also in.
Okay, the script used in Pumai.
Pumai also.
Yes, Bumai also must be. Yeah,
You will know
also-
better, no? In the
I'm not
script
aware.
is English script is used, no?
But however,
No, I don't know about Pumai.
I don't know what. But my submission here is there's no script here. The full
They do not have their script.
Yes,
So that English script is used like
For
in.
Meitei, they have their own script.
yes,
Yes, but Pumai, I don't know.
yes.
Okay.
But it must be in Bumai language.
Mm.
So the alphabet.
Now I understood because some states they use
So,
English script.
Your Honor, Your Honor, I would like to bring a citation. For the what? For the-
Yes.
Madam, your leadership, I would like to summarize that.
Mm.
That it has not been fair on me when all the persons have been released on bail or the fit individuals has been revoked. I asked the lady, and nothing has been seized or recovered from me, and only on the hearsay submission of an accused person who was arrested,
Mm.
I have been arrested. And from those persons who were arrested, substances were recovered. But however, till today, I'm 365 days is already been over. One year is already over. And if I'm continuing to further stay, another,
You're behind bars for how many years on preventive detention? 1 year?
I was given in December. So I have to go another.
August.
We are
You were
not,
arrested in August, no?
Yes, Your Honor.
Last year, 10th August.
yes, Your Honor.
So almost over. 1 year is over.
Madam, the irony here is, where I'm very much aggrieved is that investigating agency, well, my default bill was about to arrive.
Mm.
There just before, just
Yes,
they
yes.
issued the detention order. That's very biased.
Mm.
That's very biased. The honorable courts also observed the investigating agency just to block the default bill. They should not issue detention order.
All right.
And in one judgment, which is where
You are referring to Baby Devasi Chuli alias Bobby versus Union of India and others?
Your Honor, please. Yes, yes,
This
yes, yes, yes.
Which paragraph?
Paragraph here is 16, Your Honor.
Hmm.
I would like to mention here about this paragraph 16.
Hmm.
This says that the detention authority can issue the detention order on subjective satisfaction. However, the subjective satisfaction should be on cogent materials. Resting on cogent materials, solid grounds, not on hearsay. The detention authority can detain a person only even on subjective satisfaction, but on cogent materials and relevant evidence at hand. However, I was arrested in Gauhati when I was in my process of treatment with my husband, and nothing was arrested to seize from me. And the other persons have been released on bail, maybe on default bail or revocation of it in the base. However, I'm still languishing in jail. And madam, if I have to stay, even after all this violence against me, another 5 months more is left to be served till December. I have to go till December. Now it's only August. So this is regarding the subjective satisfaction of the detention authority, which states that subjective satisfaction must be with concrete evidence, not on hearsay, Your Honor. That's my most submission. Wait, Your Honor, this one, I want to also this, where in the same case, the other person's detention was revoked, who were arrested with, this is the same case of other accused persons, they were revoked.
In same narcotic PS10.
Yes. Those persons who were arrested and seized with the narcotics in their possession, they were arrested, because the authority was also of the opinion.
In the same case, their detention was revoked.
Yes, Your Honor.
Okay.
That is a judgment
All right.
for other accused persons.
Okay.
Oh,
They are co-accused.
yes,
Okay.
actually, I do not know them, but we happen to be in the same case now.
Here, what was the ground for quashing?
For having
Same.
not cogent material,
Oh,
and one was the ground that if they have a separate law, special law where the court can take trial, even if they are released, preventive detention is revoked. Madam, this is in one similar judgment by our own Gauhati High Court. And again, last year 2024, Justice Chaudhary has written like this, and one revocation of it in DPS. I'll read it out for you. It's beautiful.
This judgment?
No,
Another one.
another judgment. But Justice Chaudhary,
Devasis Borua.
yes, sir. Justice Barwan, yes.
Mm.
Born free
Mm.
as the wind blows, as free as the grass grows, born free to follow your heart, born free and nature surrounds you. The world still astounds you. Each time you look at a star, stay free with no walls to hide you. You are free as the roving tide, so there's no need to hide. Born free and life is worth living. It is only worth living if you are born free. Similar in DPS, madam. I have this judgment also. This is a beautiful judgment. I really like this is regarding the born free, regarding support the
Quoted from which poem?
one movie is there, no? That one tiger was
Ah,
caught,
yes.
one tiger baby cub was caught by the forest animals, and though he's a tiger, when he was kept in captivity, it becomes timid, no talent. So
I haven't seen it.
I will give you I have the judgment, madam. But however, the language in which I was not given should be satisfied. This should be sufficient for mine.
Yes, F for NIA. Who will raise the objection? The fundamental objection, substantial objection.
It's
You'll raise. Okay, all right.
regard to non-furnishing of the documents,
Hmm.
the language the detainee understands, your lordship. The documents will be lighted because if you go to, I have the detainee studied up to class 7 and it is quite unbelievable that she does not understand English. And then even in all the documents she signed in English, saying that even in the acknowledgement, your lordship, my counter affidavit, your lordship, in page number 29, your lordship, there's an acknowledgement signed by the detainee saying that she understands the language of Nagamis. And that is how the detention order and all the documents were explained to her in the language she understands. Page 29, this is the acknowledgement certificate.
Page
29 of my affidavit.
counter affidavit.
Yes,
Okay.
filed on 13/5/2025. Page 29, last page, annexed to it.
Yes,
This was annexed along the
acknowledgement certificate.
yes. The execution of detention order. This was executed and this was the acknowledgement certificate signed by the detainee, saying that the enclosures and everything was explained to her in the language she understands, like a miss. And your lordship, the fact that she had already filed in representation shows enough that she understood everything and then she had filed a representation as well, your lordship. And with regard to subjective satisfaction, your lordship, I would also like to rely on the same citation. The grounds in decision has been formulated.
Which one?
Lordship, that baby Devasi, your lordship.
Baby.
Yeah.
The one I just read, but
Okay.
On para 13, 16, and 17.
16, 17 and
13.
13, 16, and 17.
okay. All right. You want to read it? Yes, please read it. We already have it.
I would like to start with 13.
Yes.
In a series of decision, this court has held that it is the subjective satisfaction of the detaining authority whether a person has to be detained for a particular period of time or not. In the impugned grounds of detention, the detaining authority has narrated all the reasons for passing the detention order, detaining the appellant with a view to prevent him from abetting the smuggling of goods in future. The detention was for the purpose of preventing him from participating in prejudicial activities, Your Lordship. And then para 16, Your Lordship. It is clear that if a person concerned is in custody and there is no imminent possibility of his being released, the rule is that the power of preventive detention should not be exercised. In the case on hand, it is not in dispute that on such and such itself, the competent court has granted bail, but the appellant did not avail such benefit. In other words, on the date of the detention order such and such, by virtue of the order granting bail, even on 12/4/2005, it would be possible for the detenue to come out without any difficulty in such circumstances while restraining the principle of this court enunciated in the above decision in such and such. In view of the fact that the detenue was having the order of bail in his hand, it is presumed that any moment it would be possible for him to come out and indulge in prejudicial activities. Hence, the said decision is not helpful to the case of the appellant. In view of the above circumstances of the facts that the detaining authority was aware of the grant of bail and clearly stated the same in the grounds of detention, we reject the contra arguments made by the learned counsel for the appellant. On the other hand, we hold that the detaining authority was conscious of all the relevant aspects and passed the impugn order of detention in order to prevent the appellant from abetting the smuggling of goods in future. In para 7 of the grounds of detention, we have narrated the text, Your Lordship. And Your Lordship, in para 17, I would also like to read. For the same reasons, the other contention, namely that there is no compelling necessity to pass the order of a detention, is to be rejected. As a matter of fact, the learned counsel for the detaining authority took us through various grounds, details, materials adverted to in the impugn order, and we are satisfied that it cannot be claimed that there was no compelling necessity to pass the order of detention. We have already pointed out that it is the subjective satisfaction of the detaining authority whether the order of detention is to be invoked or not. Accordingly, we reject the above contention. Your Lordship, I have the records with me, Your Lordship. The FIR, the corroborative statements, the CDR reports, and the bank statements will all corroborate that there was the detainee was involved in sale of the drugs, Your Lordship. And Your Lordship, I would also like to take Your Lordship to the subjective satisfaction was already before the detaining authority. Everything is here, Your Lordship. The sponsoring authority had, yeah. I'd like to take Your Lordship to Your Lordship, para 13, I would like to read para 13 of my affidavit. So it's a long paragraph, I may be allowed to read
Yes.
of my content. That regard with the statement in this paragraph of the writ petition, the answering deponent denies the same and reaffirms and reiterates the statement made at paragraph 12 of this affidavit and further states that the detenue has been booked under the Preventive Act on merit of careful examination of all relevant documents concerning her by the detaining authority. The answering deponent submits that the sponsoring authority had clearly mentioned in para 6 of grounds of detention in its proposal for detention dated 11/12/2024 that the detenue was under judicial remand and that it is anticipated that given her involvement in the drug trafficking and her wide connection with spread across the state at large for bail, the accused is likely to commit or continue committing the same offense, smuggling, transportation of NDPS in the Northeast states, thereby endangering the lives of many innocent and also affect the economic stability of the state, will be a threat to peace and security of the state of Nagaland, and there is likelihood of the accused committing breach of peace and tranquility of the state. Further, this fact was also reflected in para 7 of communication of grounds of detention passed by the detaining authority, that is Special Secretary Home, dated 12/12/24, wherein it is stated that you are presently under judicial custody. On the basis of the materials placed before me, I am satisfied that you are likely to indulge in similar prejudicial activities unless you are prevented from doing so by an appropriate order of preventive detention. Further, the rights and privileges of the detenue have not been interfered in any manner since her preventive detention has been done as per procedure established by law. That the detenue had been booked under Preventive Act on merit after careful examination of all relevant aspects concerning her by the detaining authority in order to prevent the detainee from engaging in illicit traffic in narcotic drugs and psychotic substance in future and to effectively immobilize the trafficker. Being such, the question of non-application of mind by the detaining authority does not arise, and when all reasons of passing detention order with a view to prevent the detainee from involving and abetting in prejudicial activities in future are narrated by the detaining authority in grounds of detention, subjective satisfaction to detain her prevails. Your Lordship, on this proposition, Your Lordship, I would also like to rely on Supreme Court.
Pankaj Bansal?
Yes, Dimple Happy Dhakat, 2019 SCC 20 SCC.
We have got only Pankaj Bansal. Dimple.
2019 20 SCC. I'd like to rely on 36, 37, 39, 40, and 45. 36, 37, 39, 44, and 45.
36, 37, 39, 44, and 45.
Yes. This is with regard laws regarding the preventive detention. If I read it.
Yes, yes,
From
yes.
36, there are 36. Whether a person in jail can be detained under the detention law has been the subject matter for consideration before this court time and again. In such and such, the Supreme Court referred to earlier decision including such and such, and reiterated that if the detaining authority is satisfied that taking into account the nature of the antecedent activities of the detainee, it is likely that after his release from custody, he would indulge in prejudicial activities, and it is necessary to detain him in order to prevent him from engaging in such activities. Para 37. In such and such, in Para 6, the Supreme Court has held as under. From the catena of decisions of this court, it is clear that even in the case of a person in custody, a detention order can validly be passed if the authority passing the order is aware of the fact that he is actually in custody, if he has reason to believe on the basis of the reliable material that there is a possibility of his being released on bail, that on being so released, the detainee would in all probabilities indulge in prejudicial activities. And if the authority passes an order after recording his satisfaction, the same cannot be struck down. 39. The satisfaction of the detaining authority that the detainee is already in custody and he is likely to be released on bail. On being released, he is likely to indulge in the same prejudicial activity, the subjective satisfaction of the detaining authority. In such and such, the Supreme Court held that the satisfaction of the authority coming to the conclusion that there is a likelihood of the detainee being released on bail is the subjective satisfaction based on the materials, and normally the subjective satisfaction is not to be interfered with. Your records will show that subjective satisfaction materials were already placed before all the authorities before passing the detention order. Your Lordship, I also like to read paragraph 44 and 45. Observing that the object of preventive detention is not to punish a man for having done something, but to intercept and to prevent him from doing so. In narrate such and such, it was held as under. It is tried law that an order of detention is not a curative or reformative or punitive action, but a preventive action, a vote object of which being to prevent the antisocial and subversive elements of imperiling the welfare of the country or the security of the nation, or from disturbing the public tranquility, or from indulging in smuggling activities, or for engaging in illicit traffic in narcotic drugs and psychotropic substances. Preventive detention is devised for protection to society. The authorities on the subject above consistently taken the view that preventive detention is devised to afford protection to society. The object is not to punish a man for having done something, but to intercept before he does it and to prevent him from doing so. Considering the scope, paragraph 45, considering the scope of preventive detention and observing that it is aimed to protect the safety and interest of the society in such and such, it was held, liberty of an individual has to be subordinated within reasonable bounds to the good of the people. The framers of the Constitution were conscious of the practical need of preventive detention with a view to striking a just and delicate balance between need and necessity to preserve individual liberty and personal freedom on the one hand, security and safety of the country and interest of the society on the other hand. Security of state, maintenance of public order and services essential to the community, prevention of smuggling and black marketing activities, etc., demand effective safeguard in the larger interest of substance of a peaceful democratic way of life. In considering the interpreting preventive detention laws, court ought to show great concern and solicitude in upholding and safeguarding the fundamental right of liberty of the citizen. However, without forgetting the historical background in which the necessity and unhappy necessity was felt by the makers of Constitution in incorporating provisions of preventive detention in the Constitution itself. Your Lordship, the detention order was to only for preventing her from indulging in prejudicial activities. And everything, the materials, the records will show that subjective satisfaction of the detaining authority prevails, looking at the records, Your Lordship. I have flagged the important thing in the record, Your Lordship.
You have the CD,
That's the record.
record,
This record.
entire record.
Yes,
Okay.
so all those materials which were
Yeah, will
placed
require.
before, it has been flagged and.
We'll go through it and we'll give it back to you
Yes,
after the order.
yes, sure. So Your Lordship, and Your Lordship, all procedural aspects there was no procedural lapses in, and all procedure, no
In the
procedural lapses.
detention order, is it stated that there's likelihood of being released on bail
Yeah, in the grounds of detention,
grounds?
yes, along with the detention order.
Where,
Where
which
is
page?
it?
Your Lordship, in page 21 of my affidavit annex to C, this is the communication of grounds of detention. Page 21, annexure E. The relevant para is page 22, para 6.
Okay.
Para
Page
6.
22, para 6.
Yes.
Okay.
That you are presently under judicial custody on the basis of.
No, no,
No, no.
no, no. That
It is
she's
not there.
asking whether there is likelihood of
Likelihood
being
of
released on bail.
That
That
has
is
to
an
be
important
stated- That
factor.
has to be stated in the detention order.
Your Lordship, but
The proposal.
proposal is there, Your Lordship.
Let's look.
Para 7 was, para 7 is also relevant of page 22, Your Lordship.
Yes, page. No, just as.
No, actually.
No, no.
That this is one of the aspect of detention. That's why she's asking.
That you have to state
The
actually
specific- yeah,
specifically
specific.
in the order. That there's likelihood of being released on bail.
Your Lordship, but the fact that we knew that the petitioner was in judicial custody and it was before the sponsoring, placed before the detaining authority. And his detention was to prevent him from involving in prejudicial activities. So in that sense, Your Lordship, subjective satisfaction will prevail, Your Lordship, to detain him. So on, so. And Your Lordship, on procedural lapses, Lord, I will also read a statement. There has been no procedures, but all safeguards has been strictly adhered to, Your Lordship. Para 15 of my counter affidavit, Your Lordship. This is to show that all safeguards have been strictly adhered to it. I've specifically stated in paragraph 15. So your lordship, my submission thing.
Paragraph 15.
All
This
right.
perfect 15 of mine. It's at page 7. So the main object for detaining her was to prevent him from prejudicial activities and all the materials, both document material was before the detaining authority. When it's already there, subjective satisfaction to prevent him suffice alleged. And on those two authority, I rely on my submission, your lordship.
All right.
My pleasure, Lordships.
Mhm.
Lordships, I'm for respondent for
Mm.
Union Ethnic Government. Lordships. Lordships,
CGC?
yes, yes, sir. I filed my affidavit of office.
Mm.
Lordships.
Mm.
And after receiving the petition or after receiving the representative submitted by the petitioner, we have acted upon the representation and we have to consider it. And then before that, we have asking from parallel comments from the state authority. And then thereafter, we have asked the state authority whether the advisory board has taken any actions.
Mm.
But we do state advisory board has not taken any initiative at that time. So our to consider the representation at hand a little bit late. So after receiving all those two comments, the lordships, we have considered the representation of the detainee. And we have come across that there is no court material available on the record to interfere with the detention order. Therefore, that representation submitted by the detainee was rejected. And that the rejection order also served to the detainee. More particularly, that my submission is basing on paragraph 2
Mm.
of my edited opposition. So para 1 to 11. That both relevant paragraph is
Para 2 to
paragraph 2 goes of para 1 to 11.
Yeah.
That most relevant paragraph is sub para 11 euros. That represented 7, they are it, my
yes,
lordships.
yes.
That represented 7 January 2025 of Police Report Secretary Department Revenue, along with Paraguay comments of the state government detaining authority and material facts available on record. That the Secretary Department of Revenue
Just a moment. You are reading paragraph?
paragraph 2 of sub para 11 euros.
Okay. Yes, yes.
Page 4.
Yes. We are it, by
Yes,
your
sir.
lordships.
Yes, please.
That the representation stated 7 January 2025 was placed before the Secretary Department of Revenue along with Paraguay's comments of the state government, that is detaining authority and material facts available on record. The Secretary Department of Revenue on behalf of central government considered the representation and rejected the representation as he found no merits and the contentions made in the representation record. Accordingly, the rejection memorandum was issued on 13 March 2025, and the decision of the central government was communicated to state government detaining authority and jail authority by email dated 13 March 2025. The same was served upon the detainee, that is Mrs. Sarah, on 13 March 2025. And that very memorandum, that one is page 7 of my affidavit of opposition, your lordships. Page 7. That receipt is by dated on 13 Sarah. That's the detainee has received that restrictions of them representation, your lordships. That was my submission.
One last point, if the detainee appeared before the advisory board, and before that was the detainee was heard in person in Nagami's lordship. So that point may also be recorded before the detainee authority, before the advisory
Before the
board,
advisory
she
board.
was heard in Nagami's.
You have the advisory boards, which
This
page?
is here.
Oh, yeah, you have it in the case
Yeah,
there.
like-
Okay, okay. You have tagged it? Okay. Yes. Hmm. Anything else you want to reply?
My learned councils were submitting on subjective authority.
Hmm.
The central government also, the representation of our dispose was up to 2 months. I think that is also not the way to dispose after within a, because it's habeas corpus, it should be urgent also. When the central government previously have disposed of my petition only after 2 months. I wrote the in January to be disposed in March. That is also not in the interest of justice. However, my learned councils have not replied to my submission argument. Where's the strip of Nagamis? If they have submitted, I know who mine or Medilo. I was not feeling that language. Then they're stating that they've given Nagamis. Where's the Nagamis? Madam, we every morning, every evening, we hear Nagamis news in our production. We have songbooks, Bibles in Nagamis. Where is that? There's no script record of the Nagamis here in my council.
In your?
And their affidavit in opposition, as well as in the documents issued to me. So they are well supporting my prayer, my contention. But the script and my Nagamis, either Nagamis or Maiti or Kohima was not given. And which the honorable court has considered.
So documents were not furnished to you?
Yes, either in Nagamis or Kohima or Maiti in the language that I know or I'm conversant with.
That copies of her hearing were not furnished to you? She has submitted her case in Nagamis. So that document was not furnished to you?
Yes, it's not here. It's not there in the reports of the madam, Your Honor. Suppose, even though if I'm not annexed, so that the opposite council, the government will annex, but even in the documents.
Your allegation is that everything was given to you in English and then whatever is in Nagamis was not furnished to you, whatever they have stated.
They have not even stated that they have in Nagamis. They have not stated.
They have not stated, okay.
Or in Pumai or in Medilo.
Have not stated in the opposition.
Yes, it's not,
Okay.
but they have stated in Nagamis, but the Nagamis is also not there. So how will we address them?
Okay. All right. Just a moment.
Yeah, please, your lordship.
How-
Like to say.
Yes, yes. Just.
Subject-
Switch it off. No, we'll give me with this. I'll reserve it and then. Is this on now? Yeah, you wanted to sell something? Yes?
Yes. On addition to my submissions, I would like to. Eight. So para number 8.
Subpara number?
8. Para 2 of so para number 8.
Okay, okay, 2-8. Earlier you have referred to 2-11, now 2-8.
Yes, yes.
Okay.
May I read?
Yes, please.
That on 20 January 2025, the state detaining authority submitted that the state advisory board had not yet submitted its report. The said representation stated 7 January 2025, a priest of the central government was kept in abeyance pending the receiving of advisory board. As per the Honorable Supreme Court judgment dated 4 March 2020 and the matter of Ankit Ashok Chalan versus Union of India and other, that petition criminal number 362 of 2019. I'd like to read that submission of your. Much less.
Mm. Yes. Heard learned counsel, Mr. And
Assisted by,
assisted, learned senior advocate, no?
Yes.
Senior advocate, Mr. and assisted by,
YS4.
learned government advocate, Miss Ina Holi. Government advocate?
Yes, for 120.
Senior government advocate, no, learned government Miss Ina Holi for respondent number 1, 2 and 3 and learned CGC, Mr. For respondent number 4. Reserved for order, judgment and order.
Thank you, Your Ladyship.
Mm.
Please. Keep this also. After I sign the order, I'll send it to you.
For admission, item number 4. Next, please.
Mm.
Lordship, the detention order
Mm.
now.
Same, Pete and DPS.
Yes,
Okay.
Lordship.
Mm.
Okay, I would like to place this on the court, Lordship.
Mm.
Now, again, it has been extended on 14 July 2025. Lordship.
Mm.
So now, Lordship, based on this order, Lordship, now it become infractions.
Mm.
Now it become infractions.
Mm.
Now it has been extended to 18/7/2025 till 17/10/2025.
Mm. Okay.
Lordship, I have not received a copy of the order, this order.
Okay.
Just now I'm receiving it.
Mm.
I have not received. So I have an apprehension that it will be extended.
Mm.
So in my prayer portion, I have mentioned that if any other consequential orders in prayer portion of my petition, in
Mm.
point number 1.
Mm.
So my prayer may be considered to not withdraw the petition and filing afresh. Since I mentioned in my prayer portion that if any other consequential orders.
Will it work?
Lordship, then,
It won't work, I think, huh?
Lordship, that won't work, Lordship.
Any
Since now
other
it becomes in practice, Lordship, since now the subsequent order is there, Lordship.
Lordship, then
You'll have
After
to, this will be a Herculean task, amending. You'll have to keep on amending and amending, I think so.
Lordship. So it's better,
It's up to you. We ponder over it. Ponder over it. We'll fix a date tomorrow. You can say whatever you feel like.
Lordship, then if I may be allowed to file in the form of interrogatory application.
Okay. Okay, what would
Yeah, I think that can be done.
you can ponder over it.
Because he challenge is the phenomenon.
Hmm?
No, he has to challenge.
Yes, that is why he wants to continue with this petition. So-
Because if it says consequential orders, then when the court passes the order, finally, then we will have to refer to the particular order number, date, like that. So that will not be before the court. Huh? Then again,
the Lordship has rightly pointed out, means they have to challenge the.
Okay, you want to ponder over it, then we can
Or
give
you
you
can
time.
file an IA, you can file an IA also.
Hmm.
Isn't it now?
Yeah, because then we'll have to file so many records, so many amendments. There will be amendments, IA after IA. In the same, you ponder over it, think over it. You can file an IA, yes.
Lordship, I'll file in the form of I.
Okay, you want to file an I?
Yes.
Okay, it's up to you. Okay, we'll give you time then.
No.
Learned counsel, Mr.
Mahaka.
Mahaka is present for the petitioner. Learned Learned PP.
Okay.
Mr.
Is mom.
V. Jimomi is present and has submitted that the detention order of the petitioner has been extended with effect from 18/7/2025 till 17/10/2025 wide order number CON stroke PIT NDPS stroke 01/2025. What is this?
Stroke 173.
Okay. Stroke 173. Dated Kohima, the 14th July 2025. Full stop. The learned counsel for the petitioner has submitted for time to file an interlocutory application to file an IA. This is the matter after 1 week.
1 week.
Appearance, okay. Learned CGC Mr. Is present on behalf of the respondent number 4. All right. Should I give a date? Do you want a date, fixed date, or not required?
Not sure, next week, Wednesday.
Wednesday. All right, next week Wednesday. What is the date?
13th.
13th, okay.
For orders, item number 5.
Please, Your Lordship.
Mm.
Lordship, your paper book is already in done, Your Lordship.
Okay.
So the matter can be listed, posted for hearing, Your Lordship, and is it after 2 weeks, Lordship?
Matter has been admitted. Okay, admitted, long time back. We have paper book is ready. We have the LCR. Okay. Parties are represented. Paper book is ready. The LCR is before us. List this matter for hearing
Yes, Lordship.
after
2 weeks, Your Lordship.
2 weeks. Okay.
That's your Lordship.
For order, item number 6.
May it please your ladyships,
Mm.
as per the order of this honorable court dated 28/8/2024,
Mm.
I have been directed to take steps
Mm.
upon respondent number 2 through the concerned police officer,
Mm.
police station,
Mm.
and the report has come, your ladyship.
Mm.
However, inadvertently, without a governing letter, it has gone straight to the registry.
Mm.
So I just had a confirmation from the concerned police station, and they have forwarding letter, so I may be allowed to hand it over.
Order dated 20?
Order dated 28/8/2024.
28.
Page 3.
My lordship,
Yes, yes.
in earlier occasion, we have served a copy upon the respondents
Mm.
and service is complete on our part, but due to some miscommunication on previous occasions, I could not appear. So I'm appearing virtually, your lordship, and on the last occasion, we have completed service, and I right before now, I like to press before the bail petition. The petitioner is already around 4 years is behind the bar, and I like to pray before your lordship to kindly grant him bail on any condition your lordship may fit demand.
Who is appearing for the
But respondent 2 is not.
respondent
And
number?
that's
Complainant. So here I want to point out that the victim is not included as a party. As per the mandates of law, it has.
Nobody is for the respondent number 2 now?
No.
Nobody's notices have been served.
Yes, it has
In
been
this
served.
case,
So we'll have to at least appoint a legal aid
Legal
counsel.
aid.
If the respondent number notices have been served, so we'll appoint a.
Respondent number 2 is just a complainant.
Mm.
Here, what I want to,
Mm.
yes, submit is that the victim has to be a party. As per the mandates, the
No, no.
victim.
No, I think
either
victim is
or-
minor, I think.
Yes, victim may be minor.
Okay,
That is why she has not made a
Yes.
party, but
It can be complainant, it's okay.
yes, respondent number has to be represented at least.
Okay, if your lordship is of the view that.
Anyone from legal service here, anyone in the panel? Legal Service Authority in the High Court,
Okay.
who's there?
We'll appoint you then. You're an amicus curiae or legal aid?
You're also legal aid counsel.
Legal aid counsel, yes, okay. Learned counsel, Mr. Who's his name, so and so? Huh? Z Khalid is present for the appellant.
I'm here, Your Lordship.
Appellant through video conferencing. We have an IA also, no?
Yes, this I may be heard today, Your Lordship, because he's almost 3 years is behind the bar. And if you go by the records, the paper book is with Your Lordship.
No, not today, not today. We have just appointed a legal aid counsel. He knows nothing about the case. We have just appointed a legal aid counsel. Is present for the appellate stored applicant. Both the cases you can write together. Learned addition PP, no? Learned PP Miss
S. Mary.
S. Mary is present for the respondent state, full stop, comma, and has submitted that notices have been served to the respondent number 2, comma, complainant, full stop. The complainant is not represented today, full stop. What is your name? Legal aid counsel or amicus curiae? Legal aid counsel, Mr. So-and-so is appointed to represent the respondent number 2. List this matter on how many days you want? Not very long. He's behind, huh?
At least 3 weeks.
No way. He's behind bars for 3 years or 4 years, they are saying. 2 weeks. Or list the matter after 2 weeks?
Oblige, Your Lordship. Oblige.
2 weeks.
Oblige, Your Lordship.
Lordship, a copy of that.
Okay,
Yes,
a copy of the copies to be furnished to the copies of appeal memo stroke applications stroke copies of appeal memo stroke application to be furnished to the legal aid counsel.
For orders, item number 7.
Bail?
IA is for continuation of delay of 484 days.
Okay, condonation of delay 484 days.
4 days. And this appeal is from chair.
If I may please your leadership's while before the submission of the IA, the victims have approached the office of the Legal Aid Defense Counsel seeking assistance, and hence we are marking our appearance only just today. We don't have any information regarding the files and the briefs. So if hearing could be taken up.
This is also a POSCO case, no?
This is a POSCO case, lady.
Okay, then we'll have to give them time
You'll have to give copies.
and copies
The
also.
requisite copies of the petition that has been, appeal petition that is.
Learned counsel, Mr. So-and-so, appeal and applicant do both together is present before, appeal and IA both together is present for the appellant stroke applicant, full stop. Learned counsel, Miss S. Mary, no? Learned additional PP, learned PP, Miss S. Mary is present for the respondent state, full stop. Learned counsel, Miss
K. Kiki,
K. Tiki is present for the respondent complainant, respondent number 2.
complainant victim.
Complainant and victim, complainant and victim, and is submitted for time. You want some time?
Ladyship, we would want some time since we do not have any copies of the briefs.
You are legal aid counsel or amicus curiae?
The Legal Aid Defense Counsel.
Learned legal aid defense counsel, Miss so and so, and submitted for time to file to place a submission. Necessary copies to be furnished to the legal aid counsel by the appellant stroke applicant.
If
Oh, no, registry will furnish.
Yeah.
Registry to furnish. You're from the, this is, okay, registry will furnish. To be furnished by the applicant, just strike off by the applicant. All right.
Relationships.
Over?
Okay.